All right, we are at 12 on the dot. Hello, welcome to December's Planning Lunches at Noon webinar, Best Practices for Planning Boards, Proposing Zoning Amendments, Hearing Applications, and Issuing Decisions. Thank you for joining us today. So before we get started, here's a reminder on how to use Microsoft Teams webinar controls. Please put your questions in the chat and we will do our best to answer them through the webinar or at the end if there's time. So my name is Brendan McDowell. I am a principal planner in the Office of Planning and Development at the New Hampshire Department of Business and Economic Affairs. I'm joined by my colleague, Noah Hodgetts, who is also a principal planner at OPD at the Department of Business and Economic Affairs. So our agenda here today, I'll be going over the zoning amendment process for the next 20 minutes or so, and then Noah's going to jump in and talk about subdivision and site plan application review process, waivers, checklists, findings of fact, notice of decision, planning board rules and of procedure, and how to operate as a board. So real quick, just going to go over the relationship between zoning and land use regulations. In order for a community to adopt a zoning ordinance, the community has to have authorized the creation of the planning board. The planning board then adopts rules of procedure and a master plan and elects officers. After that, the legislative body can authorize the planning board to review and approve subdivision applications, including the authority to adopt and implement subdivision regulations. Then the community authorizes the planning board to prepare and adopt a zoning ordinance, then site plan regulations. So if you haven't already, you can go to our website and search for the zoning amendment calendars, where you will find different calendars with key dates about the first and last days to accept petitioned zoning amendments, the last day to post and publish notice of the first or second public hearing on the zoning amendment, last day to hold the final public hearing, last day to place on file with the town clerk the official copy of the proposed amendments and the town meeting and the date upon which or the town meeting, which is the date upon which the zoning amendments are voted on the ballot. So depending on what town you are in, go check out if you're a traditional March or May. This is a great resource. So before we get started, so what is a zoning amendment? So zoning amendments are any change to the zoning ordinance, including language, table, graphics, or maps approved by the legislative body, so through the town meeting, town council, city council. So in New Hampshire, zoning changes take the form of zoning amendments. Cities and towns and town councils can adopt zoning amendments any time of the year. Non-town council towns and village districts can only adopt zoning amendments once a year by ballot at their annual meeting. So the planning board is responsible for the zoning amendment, for the amendments to the zoning ordinance. So the majority of the amendments tend to come from the planning board. However, the governing body can also propose amendments. Additionally, there are petitioned zoning amendments, which is if 25 or more registered voters of the municipality come together, they can petition for a zoning amendment. So zoning amendment language review. And this is kind of a breakdown of what we'll be going over in a little bit more detail. So it's important to think about zoning amendment language, reviewing with the town clerk, whether the planning board supports the amendment or not, some justification, and just as a reminder, the governing body and the petitioned amendment language can't be changed. Again, we'll be going over more in detail a little bit later on. So a petitioned zoning amendment, we already started talking about a little bit. 25 registered voters can petition to amend or repeal a provision of the zoning ordinance, historic district, and planning building codes. Petitioned zoning amendments must be received between 120 and 90 days before the town meeting, which would be the second Tuesday in either March, April, or May. Petitions are submitted to the governing body, who forward to the planning board. At the first planning board meeting after the petition period, the board shall set the date for the public hearing on the petition. So the petition amendments cannot be altered by the planning board, but the board shall state if it approves or supports or disapproves or not supports on the ballot. So again, check those zoning amendment calendars as the dates for acceptance of petitioned zoning amendments in 2026 town meetings that may have passed already, again, depending on what town you are in. So the legislative process. So in towns, a zoning ordinance may be adopted or amended by ballot vote of a majority of the voters present and voting at an annual or special town meeting. Towns get one bite of the apple, so that's once per year they can change their zoning. In cities and towns, with a town council form of government, the municipal charter determines how a zoning ordinance is to be adopted or amended, although a public hearing on an amendment, and any amendment must be held before adoption, so any time of the year. So, and the planning board must hold at least one public hearing according to RSA 675:7. So public hearing requirements. So a public hearing uh, must be given 10 calendar day notice, excluding the day of the posting and the hearing. Before public hearing shall be posted in two public places in the municipality. So notice must also be published in a newspaper of general circulation in the municipality, or in the alternative posted on the homepage of the town's website. So any person owning property in the municipality can request notice of all public hearings of zoning amendments, and such notice must be provided electronically or by first class mail at no cost to the recipient. So full text of the amendment is not required to be provided in the notice. It just has to be adequately described. And it must be stated where a full text is on file for public inspection. So after the public hearing, the planning board shall vote to determine the final form of the amendment to be presented to the town, which may include editorial revisions and textual modifications resulting from the public hearing. So while RSA 675:3, Roman numeral 3, requires a planning board to vote to determine the final form of the amendment with the editorial changes after the public hearing, regardless of the input received at the public hearing, it does not provide the authority for the planning board after the public hearing to withdraw the zoning amendment and not have it go to ballot. So if a planning board doesn't want to support a zoning amendment, it can vote to not recommend it and have this stated on the ballot, but it cannot prohibit it from going to the ballot. So it's a very important note. So notification and mailing requirements. Does the amendment change the boundary of the zoning district that affects 100 or fewer properties? If yes, notice of the public hearing must be mailed to the owners of each affected property. Does the amendment change the minimum lot size or permitted uses in a zoning district that has 100 or fewer properties? If yes, notice must be mailed to the owner of each property in the district. Notice must be sent by first class mail to the address used for the property tax bills. In the case of petition zoning amendments, the petitioner must pay for the cost of the notice required under RSA 675:7 Roman numeral 1B. So zoning amendment uh, ballot requirements. So before the final public hearing, any amendment, the planning board and municipal clerk should confirm the following language is included in the proposed amendment. So, and that language would be, are you in favor of the adoption of the amendment in the town zoning ordinance as proposed by the planning board as follows? So the full text of the zoning amendment does not have to appear in the ballot. The language to be inserted in the parentheses section of the zoning amendment that would briefly describe the parts of the zoning ordinance being amended. A notation should appear on the ballot stating whether the planning board supports or doesn't support the proposed amendment. And there's a couple examples there in the middle of the slide. Add a statement or sentence explaining the reason for the amendment. Um, and after the second public hearing and the amendments have been voted on, an official copy has been submitted to the municipal clerk. They should not be discussed and debated again since they have already gone through the planning board public hearing process. So the next couple slides, we're going to go through some best practices. This is a really good example. Do not take on too many amendments. As you can see here, there's an example of a zoning ballot with 10 amendments, and it's pretty overwhelming. Probably take residents a long time to parse through all this information. So it's best to have bite-sized chunks instead of going through with 10 plus amendments. On the flip side of that, don't put all the amendments in one article. If there is anything controversial, if there's one controversial, sentence in this amendment, it could tank the whole thing. And so it's important to break them out instead of lumping them all together. So, not too many, not too few. So if you can, prepare a voter's guide for your zoning amendment, explaining what they are in plain terms. And here's a really good example, kind of a zoomed in example of what the town of Barrington did in 2024. And the next slide has kind of a zoomed out version of that. You can see it's very nicely laid out information. And Farmington, there's an additional example from Farmington. So these are really great examples of voter guides. So after the vote, clearly mark up the zoning ordinance with the year that amendments have been made, or add a section that specifies each year's amendment. So you can see here that Bo does a nice little summary at the end of what the amendments were, while Bristol marks them up throughout the ordinance. You can see letter D at the very bottom that was amended in 2013 and 2024. So that's really clear. So this is another really important point. The date of your zoning ordinance revision is when the vote was taken to amend it, not when you physically edited the document to incorporate the changes. As you can see here, the vote to amend this zoning ordinance was March 12th, 2024. However, the zoning ordinance for 2024 is said to be amended either on April 3rd, 2024, or April 9th, 2024, depending on where you look in this document. This is not a good practice and it should be avoided. So another great point is don't forget the municipal attorney. It is very important to involve and include the town or city attorney in the entire zoning amendment process to ensure the substance of your zoning amendment doesn't extend beyond the authority granted in the RSAs and doesn't violate the state or federal constitution. And a few final thoughts. for my section, so zoning ordinances are meant to be ever evolving and to reflect the changing needs of the community to protect and the protection of the health, safety, and general welfare. So they shouldn't, you shouldn't think of them as static documents. You can constantly change them and evolve them to meet the needs of your community, and you absolutely should do that. Uh, reach out to local and seasoned developers on the ground, in your communities and do some ground truthing and because they'll be impacted and with the proposed changes and just make sure that things can be penciled out, for them as well. And then, you can never do too much education and community engagement to help dispel misinformation about the impact of proposed zoning ordinances. Um, I think a great example was the city of Manchester in the lead up to Manchester's new zoning ordinance. The planning team held community meetings in every ward all summer long. So there was 13 community meetings in total, plus public hearings at the planning board. So I think it's good to remember that no one will get mad at you for doing more education and more community engagement, but they will be very upset with you if you don't do enough. So keep that in mind. And lastly, don't expect things to change overnight. It's a long-term planning process, and it'll take a little while. To for the changes to start coming to fruition. So, um, on the ground in concrete. So, and with that, I believe I'm passing the ball to Noah here.
Great. Thank you so much, Brendan. I am seeing a couple questions. So before we move on to the next section, we'll try to answer a couple of these questions. So first question from NS, is your interpretation of RSA 675:3, Roman numeral 3, that the planning board who proposed an amendment to the zoning ordinance following a public hearing at which information was provided, that then changed their mind as to the wisdom of the amendment, cannot decide to withdraw their own proposed amendment and not put it forward on the ballot? Yes, that is, I've seen communities withdraw the amendment, but best practice at least would be, given what's at the plain language in 675.3, would be you can make edits to the language, textual modifications, but to not actually withdraw, and instead to put it on the ballot with the recommendation that the planning board does not recommend passage. There's no language in 675.3, Roman numeral 3, that actually says the planning board is empowered to withdraw its own amendments after the public hearing. James has a question. Does the language for planning board amendments go to the planning board attorney or the town attorney to review? Good question. I think this is really going to depend from town to town. Some towns, really depending on the size, may have a attorney that's specific to representing the planning board, separate from the kind of general municipal attorney. Generally, if you have a planning board attorney that's more steeped specifically in land use regulation, I would definitely suggest that you give the proposed zoning amendment language to your planning board attorney to review. If you don't have a attorney specific to representing the planning board and there's just kind of one kind of attorney or law firm generally representing the municipality, then I would suggest that you give that language to the general municipal attorney. And then a question from Tim. Town of Enfield is proposing a completely new zoning ordinance to replace the old zoning ordinance. Any procedural recommendations for us? So I think this is a really interesting question. Obviously, when you're when you're proposing an entire overhaul and update of your entire zoning ordinance, you can't actually put that much detail in the language of the ballot itself. It's going to be one sentence. Do you accept passage? Are you in favor of passage of the new zoning ordinance dated March whatever 2026? In that case, I'd recommend probably that one line description saying this is the work of X number of meetings, as Brendan was suggested. For additional information, refer to some other document. And then obviously you could have an additional document, kind of like one of those voter guide examples we showed earlier, which kind of really breaks down in lay terms for those that want to see it, kind of how the ordinance has changed from how it was previously. I'll do one more question right now, and we're going to keep moving. Bill has a question, and hopefully that answered. Hopefully that answered your question, Tim. If you have another follow-up question, let me know. Feel free to put it in the chat. And then Bill's question on noticing. Newspaper posting is specifically directed in some places, but seems out of date. Is there an overarching guidance on reprieve of newspaper if other methods, website, newsletter, bulletin boards are used, or do we need to absolutely use the newspaper when it's explicitly applicable in the RSA? Yes. Generally, it says a newspaper of general circulation. Where it says newspaper of general circulation, that generally means a newspaper doesn't necessarily have to be a daily. It could be like a little like town paper, since there are kind of fewer and fewer newspapers of general circulation. For the posting, and I would fully acknowledge that the statutes are not kind of, they provide that exception for posting for zoning amendments on town websites instead of in the newspaper, and they don't for other things, right? So you really got to just kind of pay attention, I think, kind of to you've answered your own question of if it says newspaper of general circulation, then that's generally that paper. That's not a newsletter. That's not some bulletin board. If it doesn't say that, if it provides that kind of alternative to posting on a town website, then of course, yes, you can do that instead of posting in the newspaper of general circulation. But if that language isn't there, then there really is no alternative to posting in the newspaper of general circulation. All right, so now I'm going to move on to kind of the application review process. We're going to start briefly by talking a little bit about kind of the process for planning board adopting subdivision and site plan regulations. So part of the planning board's non-regulatory functions are the review of subdivision and site plan applications. However, the board must have adopted subdivision and site plan regulations first. The statutory procedures to be followed for the adoption of subdivision regulations can be found in 674:36, and for site plan review regulations, that can be found in RSA 674:44. And the requirements include public notice, a public hearing, and a vote by the planning board to adopt the regulations per the requirements of RSA 675:6. The planning board may subsequently amend the regulations to the same basic procedures. However, to adopt site plan regulations, the planning board must have first adopted a zoning ordinance as well as subdivision regulations. Subdivision regulations must be consistent with the goals of the master plan as well as the zoning ordinance for location and type of housing. Subdivision regulations need to outline the requirements for a completed application, checklist, fee schedule, and thresholds for major and minor subdivisions, etc. And while 674:36 does not require subdivisions to include a waiver provision, we do recommend to include such a provision in order to have that safety valve from any regulation, similar to what the variance process is for the zoning ordinance. Subdivision regulations are based on the premise that a new subdivision is not and should not be separate from the community, but is an integral part of the whole community, by which such a subdivision efficiently connects with the municipal pattern of streets, sewers, water lines, and other municipal facilities that provide essential services, as well as vehicular and emergency access. If there is concern, for example, with the quantity or quality of surface or groundwater, RSA 674:36 provides authority to protect water resources by requiring in the subdivision regulations documentation of adequate water supply. This could be via a study to confirm that there's adequate water supply and capacity, as well as that water supply is free from contamination that's going to service the proposed subdivision. And then, as we highlighted on the previous slide, the adoption and amendment of subdivision and site plan regulations can be done at any time throughout the year, as they do not have to go to town meeting for approval. But they do still have to follow the noticing requirements for a normal public hearing. And then, similarly, site plan regulations, as detailed in RSA 674:44, are to ensure that uses that are permitted by the zoning ordinance are constructed and operated in such a way that they fit into the area in which they are being constructed without causing drainage, traffic, lighting, or similar problems. They apply to commercial and industrial development, multifamily development, which for the purpose of site plan is 3+ units, and changes of use in a business. They may include criteria about traffic, parking, utilities, landscaping, lighting, etc. And similar to what I just mentioned for subdivision regulations, the statute for site plan review regulations outlined in 674:44, Roman numeral 1, Roman numeral 2, outlines relatively broad a number of different purposes that the site plan regulations are for. Again, including, so this could include things such as requirements for the inclusion of stormwater management standards to guard against runoff onto impervious surfaces. So I would suggest, if you haven't recently, to certainly review kind of the purpose standards for site plan review regulations to see if there's any areas that maybe your site plan review regulations, and similarly for subdivision regulations, aren't actually addressing currently issues that might be coming up that that 674:36 or 674:44 might provide you authority to regulate. And like for the subdivision regulations, RSA 674:44 for site plan also specifies the administrative functions and procedures site plan review regulations must include, including the purpose, procedures, standards for a completed application, and checklists, as well as enforcement and administrative procedures. Now, unlike for subdivision regulations, as I mentioned a minute ago, site plan regulations must include that relief valve for that waiver provision from the regulations and application requirements. So now I think, let me just see. Yep. So we'll get back into talking about checklists and waivers in a minute, but first, now we're going to talk a little bit about the actual application process itself. So the number one role of the planning board is to accept and decide on applications as laid out in RSA 676:4. And I would say, if you haven't read it recently, if there's any statute to know and to remember after today's webinar, is 676:4, as this is really the kind of rules of the road for how a planning board should determine completeness, what are the requirements for holding public hearing, deliberating on an application, voting on an application, issuing the notice of decision, coming up with the findings of fact, and so on. So the first step in the application process, as detailed in RSA 676:4, is that the application must be submitted to the planning board according to the board's either at a minimum of 21 days before the public hearing on the application, or according to the board's meeting and deadline schedule. And if you have not already, I would suggest, especially now, kind of being a good time coming into the beginning of a new calendar year, to set out your kind of schedule of meetings going forward for the year ahead, and the deadlines for which applications must be filed in advance of each of those meetings to be heard or placed on the agenda for a certain meeting. According to RSA 676:4, Roman numeral 1, subsection B, the planning board shall specify what an applicant needs to submit in order for the board to invoke jurisdiction and be able to make an informed decision. And in order to achieve the requirements, so in order to achieve, I'm sorry, lost my train of thought there. So, as we'll talk about in a minute, in order to achieve the requirement in 676 that the planning board specify what an applicant needs to submit in order for the board to invoke jurisdiction, the planning board must adopt subdivision and or site plan regulations. The subdivision and site plan regulations should include the information for what is needed to be included in the application in order for them to be complete. And then, for a planning board to determine an application is complete, the application must include sufficient information to allow the board to proceed with consideration and make an informed decision. So checklists are part of what the submission are part of what the submission requirements are for each applicant, for each application, so that the applicant knows what are the requirements it needs to fulfill to make it complete. So let's talk a little bit more about checklist. It means that you, the planning board, get to decide what information you require in an application, what information you are asked to review, and as well as kind of what are the information in the regulations that you're really kind of translating into what you want the applicant to supply in their application. Checklists are how the board can meet the requirement in RSA 674, 36, 40, and 44 that says specify by regulation what constitutes a completed application. The board should adopt checklists as part of their subdivision and site plan regulations. And this is both for the applicant as well as the board and the public to use and to understand what is expected and required of them in order for the board to comply with 674 and to be able to make that informed decision of whether it really has a completed application and has the necessary information it needs to make an informed decision on the application. If you don't already have a checklist, we have an example checklist for both, I believe, for both site plan and subdivision at the end of OPD's planning board handbook, which we can put a link to of the chat. We're currently in the process of updating both the planning board handbook and our zoning board handbook. We hope to incorporate all the legislative changes and statute changes from earlier this year. We hope to publish those updated handbooks sometime in January, so stay on the lookout for that. So a little bit more. Before an application can be accepted or considered complete by the planning board, staff for the board or the board's designee, if available, should review the application to see if it's complete. If this isn't possible, then the board can review the application at the meeting for completeness and kind of go through that checklist, but preferably this is done in advance. There's also an option, though not required, to conduct the completeness review as a conceptual consultation. In this case, the applicant applies with preliminary information and reviews with the board what the checklist and regulations required in order to have it accept an application as complete when it actually formally files, and to kind of minimize some of that back and forth during the actual formal application submission process of whether the board has all of its information it needs. This is definitely kind of a great, if possible, I'd recommend you kind of incorporating this into your kind of application process, as it's a great way for the applicant to kind of get that kind of additional time before the board and for the kind of clarify any information that might be missing from the application that the board needs to determine that the application is complete without actually kind of entering the formal application submission process. And then once the board has either the board itself has reviewed the checklist or the staff to the board has reviewed the checklist, and it's going to has determined that all the requirements, everything for fees, plans, reports, and then any other specific requirements outlined in the regulations are met. It's then going to check and see if there's any requested waivers for specific items. So, as previously mentioned, a mechanism for the applicant to request a waiver from meeting specific requirements of the site plan regulations is mandatory, but allowing waivers from subdivision regulations is optional. However, as I just stated, we stated earlier, we recommend allowing waivers from both. Applicants must show good cause that strict conformity to the regulations would cause an unnecessary hardship, and a waiver would not go against the spirit and intent of the regulations. Waiver requests must be in writing and should identify the section of the regulation in which the waiver is being requested. And the board should be clear in their reason for granting or not granting the waiver. While each board kind of does it a little bit differently, and the statute doesn't actually require this, we'd recommend as a best practice to vote on waivers individually, so that you're not in a position, the board is not in a position of voting up or down on all waiver requests by an applicant at once. There obviously may be some waiver requests that make sense. Maybe they're minor. We want a waiver from meeting some sub section of the stormwater management requirements for the percentage of impervious surface that there can be runoff to, or we want a waiver from some study requirement because it's not really applicable for this development. And so usually those waiver requests are going to be fairly specific in nature. I would caution again, if an applicant is requesting a waiver from an entire section of the site plan or subdivision regulations, say from the entire stormwater management standards, I would again go back to earlier. The applicant really would need to show really good cause that they need that waiver, and that otherwise those regulations, the entire stormwater regulations, are gonna cause an unnecessary hardship. I think generally speaking, I mean, this isn't a steadfast rule, but that asking for a waiver from a entire section of the subdivision or site plan regulations is probably generally going to go against the spirit and intent of the regulations. And I would tread carefully with that. So a little bit more about waivers. When reviewing waiver requests, the board should ask, will this affect the information we need in order for us to hear and decide on this application, yes or no? Is there enough information to make an informed decision based on your regulations, yes or no? And then work with the applicant to get the information you need. And then if you're going to deny a waiver, you need to make sure that you explain your reasons clearly and in writing as to why you're not going to grant that waiver, and refer to your regulations for support. If you end up granting all the waivers that the applicant has requested, then the application can be accepted as complete and the public hearing can begin. And the public hearing can be held at the same meeting as the determination of application completeness, as long as it was noticed to the public and the abutters that there was going to be the public hearing as long as the notice includes that there's going to be a public hearing on the application, as well as the determination of application completeness, as long as that's noticed on the meeting agenda. However, if all the waivers are not granted and the application is not willing or not showing good faith to provide additional information, or is not able to satisfy the waiver requirements, which were not granted by the board, the application can be denied. There's also the option that as I believe I'll touch on in the next slide, to continue the application review to a subsequent meeting, so that additional information can be provided. So a little bit more about kind of determining application completeness. So after the application is filed, the planning board at its next regular meeting, or within 30 days of application delivery, shall vote on the application completeness. And then, as a reminder from a few minutes ago, A completed application means sufficient information is included or submitted to allow the board to proceed with consideration and to make an informed decision. If there is a question about whether an applicant has provided sufficient information for the application to be determined to complete, as I just said, it's better for the board to either determine the application isn't complete and to continue the completeness review to a future meeting date, at which date the applicants can supply that additional information, than to prematurely determine an application is complete when it is not, and then be in the position of having to ask the applicant to supply additional information, which should have been in the original application after that 65-day clock for application review and deliberation has begun. So hopefully that's clear. So once kind of that application completeness has been determined, as stated in 676:4, Roman numeral 1, subsection C1, a planning board then has 65 days from application completeness to make a determination on the application, either approve, conditionally approve, or deny the application. There's some language in the statute there as well about the 30 additional days if the application for review, if the application has been determined to be a development of regional impact, a DRI, as well as some language about if there's a need for additional information or whatever, the applicant and the board can agree to an extension of that 65-day timeline. But generally, try to stick, obviously for complex applications, this isn't going to be always possible, but, assuming the applicant is providing information in that kind of, regularly supplying information kind of in relatively quick fashion. You're not having to wait, weeks before you're hearing back from the applicant. The statute says 65 days. Really try to stick to that 65 days for reviewing and deliberating on an application. Understanding that's not always going to be possible, but that certainly should be the baseline that you're trying to stick to. And so after the application is accepted as complete, you hold the public hearing, again, assuming that you've satisfied all the notice requirements for abutters in the public, as outlined in 675:7. And then at that point, the planning board is free to consider, review, and discuss proposed conditions of approval or reasons for denial while the public hearing is opened. And then obviously you've provided your opportunity for everybody to testify. You might provide one last chance for the applicant and abutters to comment. And then you're going to close the public hearing. At that point, the board will then begin its formal deliberations. It would discuss among the board and staff potential conditions of approval or reasons for denial. And at this point, especially for conditions and conditions of approval or for denial, be really, really clear and specific about those conditions. Include what you see fit for compliance regulations, and for conditions of approval, don't be too worried about the number of conditions. If it takes 14 conditions to get the application and development you want, and for it, as you feel, to meet your subdivision or site plan regulations, so be it. Don't be too concerned about, how many different conditions there are. It's better to have many different conditions and be really specific on what was approved and what is not and what is expected, and have enforcement and compliance issues later. Do not count on what was said at the meeting or in the minutes to be used for approvals, denials, or enforcement. So to recap, the planning board's role is to accept the application as complete or not, and review or approve or deny formal applications that are submitting. The chair's job is to allow the applicant and abutters to speak and be heard. They do not have to allow repetitive comments and can enforce time limits for individual speakers during the public hearing, if stated. And again, best practice here would be to state those actual time limits in your rules of procedure. And if there's any uncertainty by the board on whether to accept an application as complete, don't hesitate, as I said earlier, to continue acceptance. And, kind of as a theme has been throughout here, utilize your existing regulations in your decision-making process. Is kind of that kind of rules of the road that you keep going back to for evaluating. Do you feel like this application actually meets your regulations or not? And then don't be afraid, as I've said a couple times, to consult your board or municipal attorney for guidance on both determining application completeness, if the board is really kind of split on this, as well as kind of any questions on kind of coming up with those conditions of approval. So now that the board has kind of closed the public hearing and is deliberating on application, then it actually has to vote on the application. So it's in the voting mode on an application, and motions are the way a board makes the formal decision to vote on an application in front of them. Motions may be made by any regular member, the chair included, or alternate serving in place of a regular member. Motion should contain the complete action and all conditions of approval or reasons for denial. Motions require a second, they require deliberation, and they require a vote. Importantly, a failed motion is not an approved motion to do the opposite. Nor is a failed motion also constitute a case. A failed motion is also not just a majority of yeas. If the motion to approve fails, it does not mean the application is denied. It means that an additional motion must be made, or a subsequent motion must be made to actually deny the application. And then until such time as such a motion is made, discussion and deliberation continues. So another kind of key part of the application review and deliberation process is site walks. Prior to voting on an application, we'd suggest for most applications that the board conduct a site walk. Site walks can be done at the beginning of the process or as part of the application process. Just remember that a site walk is a meeting, so that's open to the public. So you need to post an agenda and take minutes, and the public must be allowed to attend the site walk. Denying public access to a site walk can lead to delays or denial of the application. And site walks are great for both fact-finding and visualizing the development in the area. If no site walk is scheduled, then individual members may view the site on their own, but just remember that unless the applicant has provided you access to actually set foot on the property, just make sure that you're not actually trespassing on the property. And then another kind of really great important tool is third-party review as authorized under RSA 676:4-B. And generally I'd recommend that third-party review, except for maybe the most straightforward, really simple applications, should be part of every application. Generally, while you are kind of the planning board trying to ensure that when you're evaluating an application, that your subdivision and site plan regulations are being met, that they've met, and again, obviously that the zoning requirements have been met. You're not necessarily technical experts, nor expected to be technical experts on engineering, traffic, drainage, erosion control, what have you. So don't just necessarily take the applicant's word on, their engineering, traffic, drainage, erosion control measures and studies. Make sure when you have any doubt to get a professional's review, whether it's your engineer on call or if you need to bring in an additional third-party professional. And those third-party experts are there to help you understand complex phased applications, controversial issues, unusual subject matters. And it's best to get an estimate for those costs ahead of time. And then, as would be outlined in your subdivision and site plan regulations, to require the applicant to fund an escrow upfront that's going to fund those third-party reviews, as those third-party consultants and reviews are always going to be paid 100% by the applicant. Make sure that you keep good records of those funds, and as I just said, put that process for selecting third-party professionals and the third-party review in your site plan and subdivision regulations, where possible, so that the applicant knows upfront when third-party review is likely to be requested. Obviously, there's going to be scenarios where odd things come up where the board may not have dealt with before. I'm thinking for example, you get an application for a wind turbine, and the board decides the regulations don't address it, but the board decides that it needs to bring in a consultant to evaluate how much noise the wind turbines are going to make. Or maybe there's a question about property values, and you want to bring in a third-party consultant to look at property values, what have you. And then a little bit more about third-party review. The role of the planning board's third-party review expert is to work with the applicant's expert to develop an improved plan, provide alternative review of the same facts, work to protect the municipality's interest, establish a basis for approval denial, as well as make sure you're utilizing your technical expertise for the actual kind of development of the project. You may need to bring them in to do drainage inspections, road inspections, ESCO drawdowns, final inspections, and compliance. So with that in mind, now when you're actually at the point of drafting your conditions of approval, conditions of approval under RSA 676:4, Roman numeral 1, is only an interim step in the process of the board's consideration. It's not a final approval. For a valid final approval under the statute, there must be no unfulfilled conditions precedent. Conditions precedent are conditions or items that must be completed in order to obtain final approval, such as revised plans, escrow funds, final documents, receipt of state and federal permits, etc. A conditional approval is not a final approval. When conditions precedent have been met, then at which point the final approval is granted. And then final plans can be signed. On the now on the flip side, there's also conditions subsequent, which are conditions or operations that are for the life of the property. They're attached to that final approval, such as the hours of operations, the maintenance or landscaping, what time lights can be turned on, a property can be lit, how much noise, decibel levels can be emanating from the property or the use, so on. A bit more about approvals. So when granting approvals with conditions, be clear which conditions are precedent and which are subsequent. If the board wants the final approval to be based on the applicant completing all those conditions precedent, make sure that you specify that meeting those conditions precedent are required prior to final approval. And be clear that failure to comply with those conditions precedent means that the applicant does not receive final approval. Don't just assume that. A conditional approval that includes only conditions subsequent, then, if it only includes conditions subsequent and doesn't include any conditions precedent, then that would constitute a final approval, or decision appealable under 677:15, and that would be appealable Superior Court. If you don't already, there's some great example kind of templates for conditional approvals that you can find in the back of the OPD Planning Board handbooks, which I think we put a link to earlier on in the presentation. Alvina, feel free to put that link in the chat again. Finally, when in doubt, as I've said several times, consult your municipal attorney. So after you've gone through the entire application approval process, then you're going to have to actually put that into a formal notice of decision that includes written findings of fact as outlined in 676:3. So a couple of points about what to include in the notice of decision and findings of fact. So first of all, the final decision must be in written form provided to the applicant and placed on file in the town's office and made available to the public within 5 business days. The decision should include specific written findings, as I said, that support the decisions in addition to conditions of approval. And failure of the board to make specific written findings of fact supporting a disapproval shall be grounds for automatic reversal and remand by the Superior Court upon appeal, unless the court determines that there are other factors warranting the disapproval. Now, the degree to which a board should make detailed finding of fact is going to vary based on kind of for an approval, whether there's any level of controversy with the application. If it's a pretty straightforward application, there wasn't a lot of testimony heard during the public hearing, it might be pretty simple to just say, as kind of outlined in this example on the previous slide, that the finding of fact is that they've met all the regulations in both the zoning ordinance and the site plan regulations or subdivision regulations. However, if there is level of controversy, and especially for denials, the board should consider what are the aspects of the application that's preventing it from saying yes, and make sure to include references to specific sections of the subdivision and site plan regulations and checklist which have not been met, and include those references in the finding of fact. Don't simply base your findings of fact supporting a denial only on the opinion or sentiment of the majority of the board about an applications. And then additionally, findings of fact should not replace conditions of approval and should not only reference meeting minutes. So we're almost at the end here, and then I realize we're almost at the hour. We'll stay on for a couple of minutes to answer some questions. So after, very quickly about rules of procedure and how to be a good board member. So after officers, so for every board, including planning boards, need to have rules of procedure as dictated in RSA 676:1. So after the officer of the boards has been established, you have your chair, you have your secretary, so on. The board should ask to adopt rules of procedure. This is the method of conduct in which the board should operate. The rules and bylaws should be adopted at a regular meeting of the board, and after being approved by the board, then is placed on file with the municipal clerk. The rules of procedure are designed to fill in the gaps of 676.4, the whole kind of application procedure. Kind of include everything from, spelling out when, the election is for the chair, the days and times of meetings, the order of business for the meetings, how to run the public hearing, how long speakers have at the public hearing, if materials can be presented at a meeting or in advance, how to deal with membership of the board on issues like a board member being absent, discipline issues, recusals, how alternates are chosen, and how they should participate. As well as what the process for applications not accepted as complete. It can also include things for how to initiate joint hearings with other boards, reconsider decisions, site walks, and committees of the planning board, or subcommittees of the planning board. And in the planning board handbook, we have, again, a example checklist for rules of procedure. If you don't have your own, that could be consultant. And it's best to always work with your town attorney when you're creating and adopting rules of procedure. And then just a couple of kind of best practices on etiquette to be a good board member. So as a board member, make sure you're doing your homework. Make sure that you're reviewing the materials, you're listening to testimony, you're making decisions based on the merits of each application, how it meets the regulations and goals of the community. Therefore, do your best to be fair and unbiased when reviewing applications. You may have a personal opinion on an application, which is fine, but make sure that you're trying to not let that personal opinion to bias how you're actually evaluating that application against whether that application does or does not meet all of your site plan or subdivision regulations, and help, kind of determine your ultimate decision of how you're going to vote up or down on an application. And then just a couple of other things. Make sure you try to work with your staff to your board, really kind of understanding the other ordinances and regulations that might kind of come into play. Make sure you're attending all your meetings. Make sure you're being respectful of your other board members and the public, even if you disagree with them. And then just a couple of things that maybe shouldn't maybe need to go, but do not communicate via email with more than with additional board members, as this could constitute a meeting under 91A. Be respectful to the public. Said that one already. And then always make sure that you're consulting your municipal attorney. And then a few more. Do not use social media. If you're a board member, and I've seen many a time where board members end up saying something on social media, say on Facebook, maybe a negative comment about a project, that could end up in an appeal in the case of a denial by the applicant about the board member having kind of a preconceived opinion on a project. So really recommend if you're a board member, do your best to abstain from commenting about a project on social media. Be open-minded to applications that, again, don't vote on preconceived notions. Try not to abstain on an application, and then unless you're recusing yourself, which you do have the option to do under 674-14. However, no other board members or the applicant can actually require an individual member to recuse themselves. That is up to the applicant. That is up to the board member themselves. In general, it's good though to look at the juror standard outlined in 500A:12 about kind of evaluating whether you should recuse yourself or not. So this is just about the end. Here's Brendan and my contact information in case you'd like to follow up with either of us after today's webinar. You can also email planning@livefree.nh.gov. And then here's a link, and I'll have my colleague Alvina put it in the chat. If you haven't seen, we did recently publish a new publication, 2025 Changes to Planning and Zoning Statutes, a guide for municipalities, which provides an in-depth summary of 13 different bills from the last legislative session, which amended the planning and zoning statutes and describe in detail what these statute changes do and don't require of municipalities. Hopefully it kind of corrects some of the kind of confusion that might be out there. And then I realize we are actually already a little bit past the hour. Feel free to put your questions in the chat box. Brendan and I are available to stay online for a few minutes. I'm going to go back to earlier on, understanding if folks need to drop off. We'll stay on for a few minutes. Okay. So James said the planning board can waive regulations adopted under the Innovative Land Use Control Statute 674-21. So the planning board can waive restrictions on a conservation subdivision. Is that correct? However, any appeal would go to Superior Court, not the ZBA. So yes, innovative land use control measures are generally optional, which meaning yes, the planning board can waive certain requirements in those controls, which are kind of different than and are the subject of the planning board, unlike kind of waiving other provisions of the zoning, or unlike other provisions of the zoning ordinance where if the applicant doesn't meet them, they need a variance. Hopefully that answers that question. However, any appeal would go to Superior Court and not the ZBA. Yes, the statute, I believe it's 677-15. There's certain things which are directly appealable to Superior Court versus to the ZBA. Yes, I believe you're correct, Jim, that those matters would be directly appealable to Superior Court rather than something that would first have to go to the ZBA. But check 677-15. Who obtains the abutter list for sending out the letters, the applicant, agent, or the planning board's clerk? So, great question. This is from Joanna. So, can be at the applicant's expense, but generally, the best practice for determining that abutters under, I believe it's 672:3, is that the municipality is going to have some kind of software, either based off usually off their assessor's database, for determining the abutters. If it doesn't have such a software, the applicant would then obviously supply their list, and then the town or the board's clerk would then confirm that that list is accurate. Okay, there's a comment there about the length of approvals. I'm going to go past that. Would agree that 65 days is usually inadequate. If you're voting in opposition of a plan, are you required to state explicitly why, especially if the majority vote is in favor, but one or two votes are opposed? I'm not sure you're not necessarily required to explain why you might be in opposition to voting on an application. However, I do think it can be informative for your fellow board members to actually understand where you're coming from, why you don't support an application. Can the planning board add a requirement to the checklist that a letter from the town engineer stating that all their concerns have been addressed to their satisfaction in order for the application to be complete? Yes. I don't think that's a bad idea. Basically saying the town engineer is basically going to certify that the checklist, that all the plans meet their requirements and the specs. If you're going to do that, though, I'd certainly make sure that that requirement is listed up front in the site plan or subdivision requirements so that the applicant knows that's going to be a requirement. Another question from Bill. Now that a town cannot require a CUP for an ADU, compliance responsibility falls on the building inspector. Can a town require an applicant to obtain a planning board recommendation to support the building inspector? Generally, I think it's going to probably depend on the situation, but no, the intent of the updated ADU statute from House Bill 577 was that the planning board, the building inspector, the applicant should not need to go before the planning board. The building inspector is still required, though, to ensure that all the zoning code, building code, fire code has been met. So it would probably typically not necessarily be the planning board providing a formal recommendation, because that would have to be in a meeting. The applicant would have to come before the meeting, but the staff, the building inspector should certainly check with the planning staff if they don't have access to that information themselves to ensure that all the zoning requirements, if they're not also the code enforcement officer, to ensure that all the zoning requirements or other requirements of the ordinance have been met for the ADU. Hopefully that makes sense. When do you expect to publish the latest revised planning board and zoning board handbooks? I expect that will happen hopefully we're in our review, hopefully by the middle or end of January. What are the limits on what can be waived? There really are, there's probably certainly some case law, which is not something that we normally deal with. But in terms of what waivers the board can and cannot issue for specific regulations, they are your regulations. So You have the right to waive or not waive whatever regulations you have adopted as a board. That said, I would be judicious in determining when an applicant is asking for a wholesale waiver from, the entire stormwater or the entire noise control section of the regulations or the entire erosion control section, to be, judiciously use your waiver powers. I'm not seeing any additional questions. We are at 110 now. We will follow. I want to thank everybody for attending today. We will follow up by email with a link to the slides and the recording, as well as a link to the webinar feedback survey form. And please fill that survey out so that we know, get our feedback on today's webinar, as well as ideas for future webinars. Have a great afternoon. Thank you very much.